Everything just changed. If you own, if you carry, if you believe the Second Amendment still protects what it says, then what just happened at the Supreme Court affects you directly. A unanimous 9-0 ruling didn't just settle one case. It detonated the entire legal framework that states have used to restrict your rights for decades. From red flag laws to magazine bans, from ammunition restrictions to purchase permits, the rules just got rewritten in all 50 states. This is more than a court decision. This is a constitutional earthquake, and if you don't know these new changes, you could be caught off guard when it matters most. So hit that subscribe button, stay alert, and let's break down every single change, one rule at a time. Because what you don't know can destroy you. The Survival Firearm is here to make sure that never happens. Chapter 1. The 9-0 bombshell that broke the system. The Supreme Court's 9-0 unanimous ruling dropped like a nuclear weapon. It didn't just decide a case. It created shockwaves across every corner of gun law in America. The case revolved around whether states could require proof of need, impose ammunition background checks, and delay constitutional rights through bureaucratic barriers. The court said no. All 9 justices. No dissent. No exceptions. And in doing so, they didn't just expand Bruin, they turned it into a sledgehammer. This ruling is now the new foundation for every Second Amendment legal fight moving forward. The decision reaffirms that rights cannot be delayed, taxed, or permission slipped into irrelevance. Any law requiring proof of need, waiting periods beyond instant checks, or subjective approval is now on death row. The court cited historical tradition as the only acceptable test. It bars states from inventing modern restrictions with no founding-era equivalent. With this one move, the court reminded every state, the Second Amendment is not negotiable, it's not subject to local politics, and it's not second class. Chapter 2. Red flag laws just got gutted. Before this ruling, 21 states had extreme risk protection orders allowing police to seize firearms based on accusations alone. No crime, no conviction, just someone's claim that you might be dangerous. This Supreme Court ruling directly attacks that framework by demanding due process protections at every stage. The court declared that confiscating property before a hearing violates fundamental rights. Ex parte orders, where you don't even get to defend yourself, are now constitutionally suspect. States like California, New York, and Colorado that skip hearings before seizure are facing immediate legal challenges. Courts must now demand clear and convincing evidence, not just allegations. Gun owners get their day in court before, not after, their rights are stripped. The burden of proof shifts from you proving innocence to the state proving danger. And for gun owners, it means red flag laws just became a lot harder to abuse. Chapter 3. Magazine bans are collapsing. One of the biggest casualties of this ruling, magazine capacity restrictions. States like California, New York, New Jersey, and Massachusetts have banned standard capacity magazines for years, claiming they're unusually dangerous. But the court just destroyed that argument. The ruling establishes that common use equals constitutional protection, no exceptions. With over 100 million standard capacity magazines in circulation, they are by definition in common use. Courts must now apply strict scrutiny to any capacity limit. Historical tradition doesn't support magazine restrictions. They didn't exist at the founding. States can't ban something because it's effective for self-defense. That's the entire point of the right. Lawsuits are already being filed in every state using this ruling as the foundation. California's Duncan case is back with renewed power. New York's ban faces an immediate constitutional challenge. The dominoes are falling, and magazine freedom is coming back. Chapter 4. Ammunition background. Checks are finished. California pioneered ammunition background checks, forcing every purchase through a state database with fees and delays. This ruling kills that system. The court held that background checks must be instant and cannot create barriers to exercising rights. California's system denies 0.03% of purchases while inconveniencing 100% of gun owners. That's not safe. That's obstruction, and it's now unconstitutional. Courts are reviewing ammunition restrictions as direct burdens on the Second Amendment. You can't exercise a right without ammunition. Restricting ammo restricts the right. States adding purchase limits, age restrictions, or registration schemes now face federal lawsuits. Washington's Ammunition Accountability Act is under attack. Illinois' FOID requirement for ammo purchases is being challenged. The message is clear: if you can own a gun, you can buy the ammunition. Period. Chapter 5. Waiting. Periods beyond NICS are dead. One of the anti-gun states' favorite tactics has been mandatory waiting periods stretching days or weeks beyond the federal instant check. California's 10-day wait, Hawaii's 14-day hold, Rhode Island's 7-day delay. All of these are now legally vulnerable. The court ruled that timely access to constitutional rights is mandatory. You don't wait 2 weeks to post on social media. You don't wait 10 days to hire a lawyer. You don't wait for permission to exercise rights. NICE completes most checks in minutes. If the instant check says you're clear, the state can't make you wait for no reason. Waiting periods designed to cool off angry purchasers have no historical basis. Waiting periods that burden repeat purchasers who already own guns make 0 sense. Courts are now striking down arbitrary delays as unconstitutional prior restraints. If you pass the background check, you get the gun. That day, not next week. Chapter 6. Purchase permits are on death row. States like North Carolina, Connecticut, and Michigan require state-issued purchase permits before buying handguns. You pass the federal background check, but the state makes you get their permission slip first. This ruling destroys that entire framework. The court held that requiring advance permission to exercise rights is facially unconstitutional. You don't need a permit to speak. You don't need a permit to worship. You don't need a permit to vote. Purchase permits are just may-issue carry permits in disguise. And may-issue is dead. Historical tradition doesn't support purchase licensing. It didn't exist until the 20th century. Courts must now apply strict scrutiny to any pre-purchase approval scheme. Lawsuits challenging purchase permit systems are being filed using this ruling as the legal hammer. North Carolina's pistol purchase permit law faces elimination. Connecticut's handgun eligibility certificate is under constitutional attack. The domino effect is already happening. Permission slips are dying nationwide. Chapter 7. Assault weapon bans face extinction. For decades, states have banned AR-15s and similar rifles by calling them assault weapons and claiming they're unusually dangerous. This ruling pulls the rug out from under that entire argument. The court established that firearms in common use for lawful purposes cannot be banned. Period. With 24+ million AR-15 pattern rifles in civilian hands, they are the most popular rifle in America. That's not unusual. That's common use by definition. Courts must now reject the dangerous and unusual test for commonly owned firearms. California, New York, Connecticut, Maryland, Massachusetts, New Jersey, Illinois, and Hawaii all have assault weapon bans facing immediate challenge. The court's logic is brutal. You can't ban something because it's effective. That's the point of the right. States can't define guns out of protection by giving them scary names. AR-15ES are used for home defense, competition, hunting, and training, all lawful purposes. The assault weapon ban era is ending. This ruling signed the death certificate. Chapter 8. Training mandates crumble. Anti-gun states love mandatory training requirements because they create bottlenecks that slow down gun ownership. Maryland requires 16 hours of training. New York requires classroom time and live fire. California requires written tests and hands-on certification. All of this is now under legal threat. The court signaled that burdensome prerequisites, even if framed as safety measures, may violate the Constitution. Historical tradition doesn't support mandatory training. It wasn't required at the founding. The government can't put expensive, time-consuming barriers between you and your rights. If training were constitutionally required, the poor couldn't afford to be armed. That's a wealth test for rights. States may shift from mandatory training to recommended training models. But requiring proof of training to exercise a right is now constitutionally suspect. Courts are reviewing training mandates as prior restraints on fundamental freedoms. The right to keep and bear arms doesn't say, after you take our government class. Chapter 9. Age restrictions are challenged. Federal law bans handgun purchases under 21. Many states restrict long gun purchases to those under 21. But the court's ruling creates serious problems for these age restrictions. The decision emphasized that rights vest at adulthood, which historically meant 18, not 21. 18-year-olds can vote, serve in the military, and be executed for crimes. They're legal adults. Courts are now reviewing whether denying adults constitutional rights based solely on age violates equal protection. California's ban on semi-automatic rifle sales to adults under 21 is being challenged. Federal handgun purchase restrictions for 18 to 20-year-olds face renewed constitutional scrutiny. The court's logic is simple. If you're an adult, you have adult rights, all of them. States can't create a second-class citizenship period between 18 and 21. Lawsuits are being filed nationwide arguing that age discrimination violates the Constitution. This battle is just beginning, but the legal foundation just shifted in favor of young adults. Chapter 10. Sensitive places are shrinking. After Bruin, anti-gun states responded by declaring everyone everywhere a sensitive place where carry is banned. New York claimed Times Square is sensitive. California said all parks are sensitive. New Jersey said basically the entire state is sensitive. This ruling obliterates that strategy. The court held that sensitive places must be historically recognized and narrowly defined. You can't just declare random locations gun-free zones because you don't like guns. Schools, courthouses, and polling places have historical recognition. Subways, parks, and restaurants do not. States that created expansive sensitive place laws are now facing federal injunctions. Courts must apply strict scrutiny to any location designated as gun-free. The burden shifts to the state to prove historical tradition supports the restriction. New York's Concealed Carry Improvement Act is being dismantled piece by piece. California's sensitive place expansion is under constitutional attack. Gun-free zones are shrinking back to their historical limits, and that's a massive win. Chapter 11. Federal agencies get checked. The ATF has spent decades expanding gun regulations through administrative rulemaking. Pistol braces, forced reset triggers, frames and receivers, ghost guns, all redefined by agency decree. This ruling creates a constitutional roadblock for that entire approach. The court reinforced that major regulatory changes require clear congressional authorization. The Major Questions Doctrine, which we've covered before, just got supercharged. A TF can't redefine statutory terms to ban things Congress never banned. Courts must now review agency rules under strict scrutiny when they burden constitutional rights. Pistol brace rule challenges are being revived using this ruling. Frame and receiver redefinition faces renewed legal attack. The ATF's days of making law through enforcement letters are numbered. When agencies try to expand their power, courts will now ask, did Congress clearly authorize this? And if the answer is no, the rule dies. Chapter 12. What happens next? This isn't just a legal moment. This is a constitutional reset. Gun owners, lawmakers, and activists are all recalculating their strategies. Lawsuits are being filed in every restrictive state using this ruling as the legal foundation. Pro-gun states are expanding constitutional carry and preemption laws. Anti-gun states are panicking and trying to find workarounds that won't survive. The ATF's regulatory overreach is under siege. Expect new bills. Expect new challenges. Expect rapid transformation. Red states will push further toward constitutional carry and permitless ownership. Blue states will fight back with new restrictions, which will immediately be challenged in court. Federal courts will become the primary battleground for the next decade, and every single challenge will be judged under this new, stronger standard. The Supreme Court didn't just issue a ruling. They fired the starting gun on a constitutional revolution. This fight isn't over. It's just beginning, and we're winning. The tide has turned. The Supreme Court has spoken loud and clear. Rights don't wait for permission. Rights don't bend to local politics. And rights don't get weaker just because politicians don't like them. For years, gun owners have played defense while states chipped away at the Second Amendment. But after this ruling, the tide is turning. The legal battles aren't over, but the momentum has shifted. If you believe in real reporting, legal truth, and staying one step ahead, hit subscribe right now. More battles are coming. More victories are possible. And this time, we're not backing down. Stay sharp, stay informed, and always stay free. As always, remember, this nation was built by armed scholars, and this nation will be maintained by armed scholars. We'll see you in the next one.